Welcome to Verdict Vantage, covering breaking news stories. Thank you for supporting our research. We would like to extend a trigger warning before we continue. Please be advised.
This video contains discussions about true crime, which may include topics such as violence, assault, and other distressing incidents. Viewer discretion is advised.
Verdict Vantage thanks you for tuning in. Your support means the world to our channel. If you enjoyed this video, be sure to give it a thumbs up, leave a comment sharing your thoughts, and hit the subscribe button to join our amazing community. Stay in the loop on future updates by ringing the notification bell. And if you found this valuable, sharing is caring. Thanks again for being here.
Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
Well, the judge's decision to dismiss the involuntary manslaughter case against actor Alec Baldwin, which appeared to match the live bullets found on the set of Rust. Now, during that hearing, Morrissey even called herself to the stand as a witness.
So I understood that Detective Hancock had communication with Mr. Teskey about trying to get those rounds, and Detective Hancock was unable to get those rounds from Mr. Teskey. I did not find that particularly concerning because those rounds had never left Arizona. The filming of Rust was in the state of New Mexico. And the rounds that were taken from PDQ went from Arizona to Texas to Albuquerque. So ammunition that is in the state of Arizona that has never left Arizona did not strike me that it had significant evidentiary value. Then, and I will say, I believe I actually saw a photo of it. At that point in time, I was able to look at the ammunition myself, and it was visibly dissimilar than the rounds from the set of Rust.
Now, Morrissey claims that Baldwin's defense was not harmed by the lack of disclosure because they knew about the bullets before the trial. Well, after Baldwin's case was dismissed, the attorneys for weapons supervisor Hannah Gutierrez filed a motion for a new trial based on similar grounds, claiming the prosecutor withheld exculpatory evidence in their case as well. In a filing, Morrissey argued the bullets are not exculpatory and that there are no grounds to overturn Gutierrez's conviction. Gutierrez was found guilty last March and was sentenced to 18 months in prison for the shooting death of cinematographer Helena Hutchins on the set of Baldwin's movie Rust in October of 2021. Now, during her police interrogation, Gutierrez admitted that she didn't check the gun.
I grew up always on the bigger side as a kid. I was always slightly thicker.
What time did you go to lunch?
Probably about like 12:30. It's pretty much on the dot.
And then, so after that, Sarah pulled them out.
Yeah.
Did you see her check them, or did she just hand them to you and that's when you checked the rounds?
She just handed us, we took them in the bag to the set, so we didn't check them there.
When you checked it, it was on set or prior to you transporting?
Yeah, it was on set. I didn't really check it too much after lunch, because it was already locked up and everything at lunch. But yeah, I checked it and put in that last round and sent it in.
All right, no date has been set for Gutierrez's motion for a new trial. All right, let's bring back in our guest. Still with us to discuss, civil rights attorney Sue Ann Robinson and criminal defense attorney and former prosecutor Marsha Minot. Sue Ann, I'll start with you. What do you make of Kerry Morrissey's attempt to get this discharge of the charges, or the dismissal of the charges with prejudice, by the way, to get them reinstated because the judge got it wrong? And mostly she's sort of basing it on the fact that his attorneys knew, and they've said they knew. They were aware of it, but they were concerned that it wasn't turned over. What do you make of all this? It's such a mess.
I think that Morrissey is trying to redeem herself, as any lawyer would, in a situation where a case of this magnitude, a high-profile case, gets dismissed, and the judge puts it squarely on her misconduct and on her shoulders. She's saying, hey, I need clarification on why, because my understanding of it is that, you're somehow saying this evidence that I withheld was exculpatory, and it wasn't exculpatory. And then, of course, the defense's job is to defend. So then they're going to say, well, of course, I would have magically put it together in such a way that it, of course, would have been exculpatory, because that's what the standard is to maintain their motion to dismiss. So I think, Morrissey is, of course, trying to redeem herself, redeem her case, and say, listen, even though the judge has read her order and decided that there was some misconduct that would have affected the outcome of the case, and therefore the sanction was to dismiss, it's the wrong standard, it's the wrong thing, and she wants the case back. And of course, Gutierrez's lawyer is doing what I would do. If Alec Baldwin case has been dismissed, then mine should too, because we had the same evidence and the same prosecutor. So I get it. It's just, it's a situation where the judge made the call based on what she saw, and that's her job, to call the balls and the strikes. So the prosecutor said, I want another opportunity, I want clarification on it.
Yeah, and Marcia, you know, it's really one of the worst things that a prosecutor can be accused of is withholding exculpatory evidence. I mean, when you talk about having fair trials, that just cannot happen. And I think that kind of colored the judge's decision, her sense that that's what happened. That's why she thought the right result was dismissal with prejudice. But I gotta say, and I understand this may be about protecting her reputation, but do you think Carrie Morrissey has a shot of getting this case going again?
I don't think she has a shot. Prosecutors are not permitted in any state to determine the evidentiary value of evidence. They are required to turn it over and let the court decide what they think is evidence and what is not evidence. So in this situation, she's very fortunate because remember, a judge has the authority to report her to the state bar and ask them to take proceedings against her. So she really has a lot of gall pushing this issue after the court found that her conduct was inappropriate. You don't want to ever push a judge to the corner where they're going to request that the state bar investigate you for losing your license.
Yeah, I gotta think she's doing this for reputational purposes. She wants to get on some record somewhere out there that this was her position on it. So, you know, it's viewed in a certain light as opposed to the way it was left when these charges were discharged. But as far as, and I want to go back now, Sue Ann, to the Hannah Gutierrez situation, the problem there is not only are now these bullets, being brought to the fore, there's also another report by a second expert used by the state to do some testing that showed that there was some minor microscopic impurities or imperfections on the gun that was never turned over. So she's got another problem there, Carrie Morrissey. But at the end of the day, and I think this goes back to something that Marcia said, the state can't make a determination as to the value of evidence, which sounds like what she did, because the defense is claiming, had we known about these bullets, we might have taken a different approach to the case.
Right, and that's what the defense is going to defend. That's their job. And Morrissey is saying, hey, listen, you had the opportunity to cross-examine the expert and you never elicited that testimony about that other report. So that's on you. And even if the report would have come out, it would not have been exculpatory, which is a very high standard. And the idea is, you know what, if everybody that's in jail was allowed to say, hey, there was evidence that was never introduced in my case, so I deserve another shot, then supposedly there's some floodgates that would be open. So the standard is it has to be evidence that would have been exculpatory. So the prosecutor is doing what she has to do, which is saying it wouldn't have been exculpatory evidence. Even if it was more evidence, the jury still would have found Ms. Gutierrez guilty, even with that additional evidence.
Yeah, and I think that's a bit of a stretch, Marcia, because a big part of the state's case was that she was responsible for bringing those bullets onto the set. That was part of this overall sense of recklessness that led to her conviction.
That was the entire catalyst by which the prosecutor presented their case to the jury. They argued that but for her bringing that one live round to the set, the person who was deceased would not have died. When there's now evidence that other live rounds were at the set and you denied her an opportunity to have those rounds tested, fingerprinted, and to determine where they came from, including but not limited to potentially from the person who was dumping bullets at the scene after the incident. Of course, that is critical. And there's going to be a problem, and I expect a motion for new trial to be granted.
Wow. Okay. I was going to ask you that quickly to tell me, and you already told me.
At Henry Meds, our knowledgeable providers demystify compounded semaglutide, the same active ingredient in brand name weight.